So the next session is part of the legal clinic at Dev.Play feature. And it's one of the first of two sessions on legal topics, today covering mergers and acquisitions and investment. This is a pre-recorded session, so unfortunately the speakers could not be present here today. But please, it's a session that we highly recommend, very interesting for independent developers. So I let you in the hands of Patrick Sweeney and Silviu Stratulat. Enjoy.
Hello, my name is Patrick Sweeney. I'm an attorney at the Interactive Entertainment Law Group in Los Angeles. Welcome to Dev.Play. Very happy to be here presenting to you today on corporate transactions and an overview. And I'm honored to present with Silviu Stratulat as well. So we're going to talk about general overview of corporate deals from a international as well as a local perspective, things to look for, and some of the areas that we normally see where things get heavily negotiated or bogged down, and familiarize everybody in the audience with the process. Silviu, welcome.
Thanks, Patrick. Hi, everyone. Very good to be back at Dev.Play for a second year in a row. I'm delighted to be co-hosting this session today, which, as my colleague mentioned, hopefully will give you a bit of an insight into the world of M&A transactions, including in relation to the very hot topic of financing rounds. We will also try to address all concepts, which some of them might be known or some of them might be unknown to you from a dual angle, the Romanian and the American angle. As some of you might know, I'm a corporate lawyer. I had M&A at Stratulat Albulescu, a full-size Romanian independent firm with a big technology focus. We do a lot of transactional work, including in the space of gaming. Only this year we've done two deals which are relevant to the market, acting for the founders of Metagame on the sale to Fortis, and for machinations in relation to a follow-on financing round. In this session, we are hopefully to be able to offer you both a legal but also a business perspective. We have experience in advising and steering.
Yeah, I agree. I think a lot of my clients that I see don't understand the process going in, and they're a little bit intimidated by the process. I think traditionally they view it as similar to a publishing deal, which is one document and takes a period of maybe 1 to 3 months sometimes to negotiate. Whereas the processes that we're going to walk through today in this session are a bit more complicated, a bit more time intensive, and as you'll see, have a lot of different moving parts to it, which can be difficult to coordinate. So with that, we'll jump in. We've got a presentation that we will share. Here we go. There we go. As we mentioned we already provided the introduction, so we'll move on to the next slide. Obviously, here we are. Here are some of the representative transactions that I've done in most recent years. The most notable recent one was Netflix purchased a client of mine, Boss Fight Entertainment, out of Texas, integrating them into their new games program. But as you'll see, there's a bunch of others here. Been opposite Tencent and Bitcraft on a few deals. Been opposite AppLovin, opposite CD Projekt on its acquisition of a U.S. studio, which was last year. So it's a wide variety of different types of deals. And I think, as Silviu mentioned, here's a snapshot of the deals that his firm has worked on. If you want to talk about any of them in particular, Silviu.
Yeah, I mean, I've already mentioned machinations and Metagame. Our client portfolio includes venture capital funds such as Catalyst and Gapminder. But we do a lot more in the technology space and not only in the gaming space. So we've acted on various financing rounds in relation to Xvision, Coda as well. We've done deals, financing deals in Cardloop, Frisbo, Timeping DNA. We've done one of the largest financing deals in the market this year, a $15 million round in Druid, acting for Druid this time, not for the VC or the investors. And we do a lot of traditional M&A work. For instance, we've acted for SIBS, the largest Portuguese payments group, buying the Wirecard payments business in Romania, previously known as Supercard, Romcard, or Provus, the group holding those two assets. I think it's just a very well combined mixture of M&A, traditional M&A, and more VC focused, VC driven financing, new age work. So that's probably going to gives you a bit of a hint of basically what we're going to have in mind when we're going to run through the concepts and walk you through the stages of both financing and M&A, traditional M&A deals.
Great, thank you. I think the point of these last two slides is to show everybody in the audience that every deal is very different and every deal is unique. But I think for the purposes of this panel, we're gonna talk about the general structure of a couple of types of deals. So the type of deal that's a very early seed round, which is less formal, friends and family round is often called, where people are just investing in a concept. Usually that's done in the form of a convertible note or a loan that eventually becomes stock. We're not really going to talk too much about that. We're going to talk more about the more formal seed rounds and the acquisition because they have a lot of commonalities to them. In both cases, you have either a strategic or an institutional investor. Strategic being somebody who actually is in the game space and might add value beyond just money, whereas institutional is just really more of a pure financier. And it's about the rights that they all get when they're investing, whether it's owning the company outright or investing in a minority basis. So a lot of the same structures appear in both. So I think we're going to talk about them sort of jumbled together. But in the previous two slides, I think there was a mix of both kinds of transactions. So first, I want to talk a little bit about the pre-deal environment. So this is before any paperwork has really been shared, before there's anything more, not even a handshake at this point. So generally speaking, there's a process of some level of sort of courting or dating each other to figure out if there's a fit, right? Whether that's culturally or certainly financially, to decide what everybody wants. And again, this goes back to whether it's an institutional investor or a strategic. And then at some point in there, usually the companies will get under a non-disclosure agreement so they can talk a little bit more freely. And then they'll start sharing some high-level information, some basic economic information, financials, who owns the company, how much you're willing to invest. And decide possibly what they're going to do together. That process can take a while. I mean, I know companies that have been sort of doing that courting for years, right? They're trying to sometimes they wait to see how your next game does or any of that. Normally, I don't think lawyers are involved too much in this, and certainly not on my side in the U.S. Silvia, you can chime in.
No, absolutely. No, not in our geography either, actually. And I wouldn't advise in involving lawyers at this stage, just because basically they might, as much as I like lawyers and I like myself, they might just complicate things too much for the stage.
Yeah. I think the only level of participation I have in this pre-deal stage is in the background, right? My client might say to me, "Hey, I talked to so and so today," and I might say, "Well, keep in mind you don't want to talk about this, or you might want to keep this in mind. You've got some obligations here. Don't let it distract you from your business operation." But yeah, I agree. We're never really out front in this stage. Just more in the background waiting because we know we might have to pivot real quickly and move. But if this all goes well, the next step would be that this results in a term sheet, right? And a term sheet on the U.S. side for these types of deals is just usually a non-binding agreement that basically says, if everything checks out more formally, we will pay you this. We will own this amount of money, or that percentage of your company, or all of it. You'll operate your business in the same way, and it lays out the general structure. I think the only real important parts here to note is that there are a couple of binding provisions. Normally, the company that's being invested in or being acquired will promise at this stage not to talk to anyone else for a period of time. So this is an exclusive window where the two sides decide, this is getting more serious. We're going to, we're gonna stop talking to other deals. There's potentially a fee paid if things fall apart and you decide to walk away, because everybody is diverting a lot of assets here. But that isn't even a certainty. But other than that, no money tends to change hands here, and it's all subject to a full review from a due diligence standpoint. This is the stage that I usually start seeing some activity on the legal side. The term sheet tends to be heavily negotiated in the US, only because it's precedent for the more binding documents. And I assume it's the same for you on the Romanian side, Silviu?
Yeah, Patrick, absolutely. I just wanted to add something on the courting stage, so pre-term sheet stage. Set one piece of advice, which is very important. Set your goals. I mean, even write them down on a piece of paper and set your goals. Do understand what you're trying to get out of that negotiation or that discussion. Understand the level of cash you need, understand how much you can give away for that cash. Understand what is basically, if you need the smart trade of the money, if you need basically the scaling up, the help in scaling up your business, see if it's a good match. See if basically, for instance, the strategic or the prop or the fund who wants to invest with you, if they own businesses in other territories that might help you, get to the client or reach out to more people or a wider audience generally, or penetrate or just enter certain countries which otherwise would be difficult to enter. When it comes down to term sheet, here is quite the opposite of what I was saying in a courting phase. I would really suggest you involve a lawyer here, because I agree 100% to everything that Patrick said, and most of the terms of the term sheet would not be binding on the parties. But regardless, once you sign a term sheet with a certain set of conditions, you cannot walk away, and it's really not customary, and it's not nice actually to try to alter them afterwards. So once you sign the term sheet, regardless that some of its provisions are not binding, you have to stick to it for that transaction, and it would be extremely unpleasant and ungentlemanlike actually to try to negotiate an alteration to those terms. So that is very important. Everything else that Patrick underlined here is applicable to Romania. It's you could have a breakup fee. You would have certain terms which would be binding on the parties. For instance, exclusivity. It's very common in Romania for term sheets to contain exclusivity. It's also very common for a term sheet to contain, and I urge you, if you're a founder of a business, I urge you to try to negotiate a very, very clear confidentiality provision in the term sheet, because that is something that you need, and it protects your business, it protects your idea, it protects the future of your company. So that's something very important. The term sheet is a summary of everything that will come, but also sets the basis for the future marriage with the investor, for the future relationship, if that goes through. So try to pay attention, and again, try to involve a lawyer, because they have a better understanding and a lot more experience in dealing with term sheets, and they can explain to you the various terms and conditions. And sometimes it's the commas and the dots in the document that make a whole lot of difference. In just one sentence, you could have terms which are customary to this type of transactions being built into the further transaction documents or excluded from the further transaction documents. So, right back to you, Patrick.
Yeah, this is an area, I think, as you said, where you had your handshake deal, you've determined what your fit is strategically, that culturally you're a good combination. This term sheet is the first document that actually really recites that. So I think it also sets the tone for the whole negotiation. So you spend a lot of time on this document, at least I tend to, and seeing how this document negotiated often dictates how the entire transaction will go, which we pay attention to, I think, on the legal side. But if the document, if the agreement in principle is basically, I just want your money, you're going to leave me alone, let me run my business, the term sheet's going to reflect that in some of the ways that some of the terms. If it isn't, if it's going to be more of a full combination and an integration of your two companies, the term sheet's going to show that too. So getting that right and having it reflect the handshake that you did a few weeks earlier, I think is really important at this stage, even if it is non-binding. Then we move on from here is to the due diligence process. This is where I've already been involved at the term sheet phase. Now I bring my entire team in, right? This is more of an all hands on deck, and I imagine it is for Silviu's team as well. What happens here is the investor or the acquirer basically says to the target company, I want to see everything, right? So far they've seen financials and maybe they've seen your ownership table, your cap table. But here they want to ask a lot of questions about what IP you have, what everybody who's ever worked there, are there any potential claims or litigations or liabilities that you might have? Show me the lease for your offices, your last set of tax returns, everything. And what they're trying to do is verify what they're investing in or buying, right? So they want to make sure they've seen everything. There are no surprises, and there's going to be likely some in most cases, unless you just started your company and you have one idea, no employees. There's going to be some historical projects that you put on the shelf, or some failed contracts, or maybe a collection matter, or things like that. So they want to know what they're buying and investing in. So this part, I think, from my perspective, is very time consuming and can take, I don't know, sometimes a couple of months. I've seen it in some deals, and not only that, it never quite ends all the way through closing. There's a phase that sort of closes out, but then it gets supplemented as things go on. So this is I think really where, at least from the legal side, I think there's a good chunk of our fees start to add up in our time spent.
The key here, from my experience, is patience. Patience, and try to appoint someone. If it has to be you, the founder, then basically it's you, the founder. But if you can appoint someone who has very good relationship across all departments within your company, who has a good relationship with the CFO, who has a good relationship with the sales, who has a good relationship with marketing, accounting, and so on and so forth, because that person will have to collect all the information requested by the investor or the buyer in this process. And the initial request list, the initial request of information might be something scary, because it'll be about a dozen pages of requests for information, some of which you've never heard of, right? Some of which you didn't know it exists, some of which you didn't know it was applicable, and some of which is actually not applicable. So just if something is not applicable, just mark it as such on the list. I mean, don't try to create documents or provide the investor with information that should not exist. And due diligence can be prepared in advance, and larger companies would basically run or could run a vendor due diligence, a semi-vendor due diligence prior to the due diligence conducted by the investor. I know that that's probably not the case for most of your companies. You do not have the size, the manpower, or the time to dedicate. But what I can tell you is that the key areas here in gaming would be IP. So look into your IP, see that it's well transferred, see that the rights are owned by the company and not by you or by a friend or by someone, a third party. So IP would be essential. Employment is also always essential, because basically the investor puts in money in reliance to your team and yourself. So make sure you have all those employment contracts, the interior regulation, and you don't have any disputes with your employees, and so on and so forth. Corporate, and this is the general, good housekeeping of corporate matters. And last but not least would be privacy, which is now, as Patrick would know, and Romania as well as in the States, a big thing with the GDPR applicable, and with fines being a percentage of the revenue. It's an area of high interest to investors. So try to look in these areas before basically going forward with the due diligence. It might take you a few days but invest the time because it will be productive. And also learn from the additional set of questions that will be asked from you. So there will be an initial set of questions which you will ask and address, and then the further questions addressed to you would probably be very specific after or post review of the first set of information. That should give you a hint of where the advisor, the investor's advisor, is taking this, or what maybe they have identified something, and maybe you would have the time to remedy it. So try to read in between lines for those further set of questions, because that is, that will help out the process a lot.
Yeah, I agree. And the last point here, I think as well, is I always recommend complete transparency with my clients in the disclosure of documents or issues or problems. It's going to come out eventually. And this is somebody who is either going to be a minority investor in your company or your boss, post-transaction in an acquisition. They're not looking for surprises. So I always recommend, even if there's something that you're not proud of, get out in front of it. Let's figure out how to address it, but you're still going to disclose it, right? Moving on from there, and while this is going on, there's a preparation of the definitive documents. You don't have to wait until the due diligence phase is over, thankfully, because that phase can go on for a while. But that disclosure period, that due diligence phase, will often dictate the structure of agreement. So if they see that there's a lot of failed games or a lot of situations there that they don't want to invest in or buy, they might structure it as an asset deal where they only buy certain parts of your company and leave the rest behind, or they might buy a pure stock deal. So depending on the results of due diligence and some other factors, we'll decide how to structure this deal. The good news here, and unfortunately good news is always followed by bad news, which we'll talk about later. The good news here is that this one document is the majority of the transaction, and it generally is based on some uniform templates, at least on the United States side, that have been vetted for lots of transactions, not just in the games industry, that are commonly acceptable, but they're still heavily negotiated on the specifics. But at least you don't have to pore over every word quite as much. So I think it does save time. And I believe those standard templates are probably utilized throughout Europe as well, and certainly in Romania. So I'd love to get Silviu's impression on that. But this is the first document that basically reflects the term sheet in totality. Unfortunately, it's not the only document, which is the bad news that we'll talk about in a little bit later.
Yeah, unfortunately, I think the Romanian business environment hasn't been that diligent in putting together a very specific set of templates or precedents which companies and investors could use, such as in the United States, or for instance, the United Kingdom. They have the BVCA, the British Venture Capital Association's standard precedents applicable to at least financing rounds. I think that there is not a big variation or a very wide variation of the transaction documents here in terms of precedents in the market, but there might be a variation between various firms, international, local firms, or even investors, venture capital investors or strategic investors might have a different approach to things. And then there is also the angle of governing law. Romanian law is quite different to common law jurisdictions or legislations, right? I mean, English law or U.S. law is different, although governed by the same principles. In practice, it is or can be very different. And then even though standards might be international, they might be substantially altered. Concepts might be substantially altered when it comes to a Romanian government document. But again, let your lawyer guide you through the advantages of having a Romanian law governed or a foreign law governed transaction. It's something that the investor might be very rigid on. And I would say that they might be rigid or might insist a lot in having a foreign law governing those documents. it might change a lot. It might be something that might cause the deal to break if you don't agree to that, just because it's true, Romania, there is very little case law around Romanian law governed documents and transaction documents in M&A and venture capital. Although now basically there is a pretty well established practice, but you have to understand that you know, Romania is a jurisdiction as opposed to other countries, and in terms of Romanian law, it's, you know, commercial use of Romanian law for commercial M&A purposes dates back to you know, just a tiny piece or a tiny portion of the span of time American law or English law has been applicable. Also, if you have an American investor in an M&A transaction, then basically they would be accustomed with the same type of standards international. But if you have an an American investor in a financing round, they might not be so accustomed to the European standard, because there is a European standard. For instance, the American market, and correct me if I'm wrong, Patrick, does not make use of the shareholders agreement, but it's actually, instead of a shareholder agreement, they have this whole set of governance documents, which include a voting right agreement, and you know, and it's a lot more complicated, and basically this is why American investors would be less acquainted with the shareholders agreement, and they might need guidance as well from their counsel, local or European counsel, in addition to the American counsel who might be on a transaction. Now, if it's a traditional M&A transaction, so if it's a minority or majority investment into your company, but a traditional M&A transaction, then things might go smoother than in the financing round. Also, because basically that strategic or that fund might have done other deals in the region or in Europe generally, so they might be already acquainted with a shareholders agreement and so on and so forth, right?
Yeah, no, you're absolutely right, and for this reason, I always have local counsel with me on every deal, regardless of where my client is located, and that's true in the United States, among the 50 states as well. I always have local counsel that I work with for some of the state-specific issues. In the United States, you know, the laws can vary wildly from state to state in certain areas, particularly employment. But certainly when it's a U.S. company and a foreign company, or a non-U.S. company, I'm always having local counsel that I work with for issues like that. Employment, IT issues, I think, you know, certainly tax issues are not something that I think the common templates that the U.S. uses necessarily have contemplated when working with, you know, clients that are non-U.S. based. So the document from the prior slide, the stock purchase agreement, asset purchase agreement, whatever the structure is going to lay out the core terms. The upfront money that's changing hands, whether it's cash or stock, the earnout, which is basically the non-guaranteed portion of the purchase price. So some of that could be tied to a retention of employees, you know, completing certain goals, revenue-wise or whatever. Implementation of better option plans for employees, depending on the situation. Amount of people staying, some of the key people. You know, I've done deals where 75% of the existing employees must stay on an employee fashion, or else the purchase price slides down. That was not something that got a little complicated and very granular in some of it. But then it lays out some of the other things that are less compensation driven. How much visibility the investor or the acquirer is going to have on a board seat, what rights that everybody has at selling their percentage of ownership or issuance of new stock, and having that investor come in again, and veto powers and the conduct of the business. So, you know, for example, I'm sure Netflix wouldn't want to buy a company that was on the game side and find out that they just want to move into you know, anime, you know, cartoons. Maybe they would, maybe they wouldn't. But an entire shift of the business model, or taking out loans, you know, against your assets, or things like that, or expanding, you know, to a certain degree, or closing down a business unit, things like that, an investor is going to want to have some say in and some visibility, or a veto or approval right on. So these are going to all be laid out in the purchase terms. It's a very thorough document. As I mentioned, unfortunately, and as Silviu intimated in the last slide, it's not the only one. I think this is where many of my clients get confused by the process. They're used to a publishing or a project financing deal, which is one document, right? And they look at this as the one document, and then they're a little bit stunned to realize there's a whole lot of other documents that come into play here. But this document is pretty heavily negotiated. It's basically the term sheet put into a more binding long form. You know, it can be 20 pages, can be 50 or 75 pages. You know, and we spend a lot of time obviously negotiating it. It can be, you know, it can be done in a month. It can be done in 3 months. It sort of depends. But again, this is really more the core taking of the terms from the term sheet and putting them into a larger document. Anything to add here from your perspective?
Yeah, absolutely. I mean, some of those terms might not be well understood at first. For instance, you know, I mean, earnouts, investings, and things like that are some of a mystery for the average founder of a company. I mean, it's not a problem. Please, I mean, ask your counsel. Even ask the investor. I mean, ask for. I mean, they shouldn't have any issue to explain to you what exactly those terms mean and how would that, you know, how would those things roll out and develop in practice. It's important to understand how you will control your company and whether you will have full decision or just a say on operations and going forward actually in a company. And this is why, going back to the courting phase, it's important to set goals. I mean, try to understand, you want to run your company and have a passive investment. Do you want to have an active investment? Do you need someone from the investor on the board as an advisor? Would you be comfortable that person on the board you know, having a veto against certain decisions, and which decisions those are? Take the time to understand all that set of rights and also obligations, undertakings, and limitations which this might create on you and your business. These limitations are in no way something negative. I mean, it's not like someone will really cuff you and won't let you get on with your business and develop and grow your business in the same rhythm. You have to understand that this is the way it should be, right? The sole purpose of the investment is to help the company grow and you know, profit or greater profit and greater notoriety should be a common goal between you and the investor. And this is the merit. And it sits as the basis of the resolution to invest. And you should know this if you're going to go forward with that investor. If that investor has something else in mind, if he is a competitor and is just trying to pull you to the side, then you have to weigh very well your you know, your decision here to go forward. It's very important to understand where you want that. Or you want to grow your business. So that's something that I would like to say. And then there's a lot of issues here around you know, your liability for the business, for the way that the business was carried out prior to that transfer of interest in the company. That is also something that could be limited. Don't get scared about the past unless you have reasons to be scared or you know, specific issues that might not let you sleep at night. And even so, try to disclose them to the buyer. The buyer should be very conscious of what he is, or the investor should be very conscious of, you know, what he is investing in. And of course, you know, liability would be, you wouldn't be, in principally, you wouldn't be liable for everything that you disclose to the investor, and will be defined or regulated as such in the transaction documents. So information that is disclosed to the investor is essential for you know, the level of liability you would have against issues or losses that might occur later on. And again, those losses could only be attributable to past, so prior to closing issues. So the conduct of the business prior to closing would be the only circumstances that could give rise to your liability towards the investor, and not post, right? That is, everything that happens afterwards, that's a different thing and should not fall under the liability set out or set by the transaction documents.
Yeah, absolutely. One more point on the earnout, going back to that component. This is an area that I think is not 100% transferable from the term sheet to the definitive document. So, I had a deal where on the term sheet they said, if your next game makes $50 million, the purchase price will go up by another $10 million. You'll get another big chunk of money. Well, when we got to the definitive documents, they had the buyer had the ability to cancel the existing game, right? It's complete discretion. So the earnout wasn't necessarily achievable. So if the acquirer wanted to get out of paying that, they could just cancel the game. So making sure that the earnout is somewhat objective in the criteria versus subjective isn't something that I think is fleshed out at an early stage, and you spend a little bit more time here making sure that it's something that you can earn. Otherwise, you really just shouldn't count on the purchase price, and you think you're getting a deal for a certain amount of money, and then you're not. So there's a lot of time here spent making sure that this larger document doesn't completely undercut what the agreement in principle was earlier on, and I think that's one of the key areas. Moving on, as I mentioned, the good news and the bad news. The good news is the purchase agreement tends to be more of a template that's universally recognized, at least as a starting point. The bad news is, at least on most U.S. deals, there's a lot of other documents that go into this. So here's a list of sort of the ancillary documents that you tend to see on the U.S. side in a deal, whether it's a seed round or even an acquisition. So non-compete agreements, all the consents and all the certificates. A lot of them are formalities. Some of them are heavily negotiated. A lot of them are formalities, but you have to deal with another dozen or so documents, and this is time consuming. I think this is where my team really steps up and handles this. I'm not necessarily looking at all drafts of the stock certificate all along there. There's only so many hours in the day, so I think this is where a good legal team at your disposal helps. We spend a lot of time on this. Maybe half of them are formalities, and the other half are more contentious. But the only problem here is you have to sync all of these up to be in final form in order to close the deal. So again, I don't know how many of these documents are pertinent in the average deal that you see, Silviu, but unfortunately, these bog down a lot. Opinion letters, for example, are not in every deal that I do. Legal opinion about IP ownership, or where somebody stands on privacy, I've seen in the past. But a lot of these other ones tend to be in most deals.
So we would definitely see most of these ancillary documents in our transactions. For instance, I'm looking here at disclosure schedules, absolutely. And most of the transaction would contain a disclosure schedule. We always have, amended bylaws, and you always have employment agreements. We have the concept of a management agreement here in Romania, which is the equivalent of an employment agreement for management, and an alternative. And by the way, on a choice between these two type of documents, if you are a founder selling part of your business to an investor, or giving way, I would really go for an employment agreement. It protects you a lot more than a management agreement. Just as a practical advice, you would definitely see a closing certificate on most of the traditional M&A deals. I wouldn't say that you see it. It's not very common in financing deals. And looking at all the other types of ancillary documents that you've laid out in this picture here in the slide, yeah, absolutely, most of them would be applicable in Romania. It's something that is time consuming, but at the same time, for instance, if you have a minority investment into a company, you would, or even a majority investment, you would have a shareholders agreement. The bylaws in Romania would reflect some of the statutory provision included and built into the shareholders agreement. And so once you've negotiated a shareholders agreement, you know, just transposing, taking those provisions into the bylaws should not be an issue, should not be a problem, but it's time consuming and you have to make sure basically that you look very closely into it. What we see is heavily negotiated is either the employment agreement or the management agreement. And that is very, very often linked to certain provisions in the shareholders agreement, for instance, leaver provisions. Leaver provisions are common in both minority and majority investments, where the founder plays a very significant role in the future of the company, and basically its stake in the company, its interest in the company is dependent on the continuation, you know, of his role as a manager or part of the management body in the company. And we see a lot, you know, management agreement would contain provisions or that would allow the company to terminate it on default, for instance, by the manager, and termination on default by the company led by the investor in the background basically could lead to you know, a forced sale of interest for a very low valuation of your shares in the company. So, you know, all of what I'm trying to say, and it's very important, all of these documents are interconnected, and you really need to pay attention on, you know, cross references and cross consequences between those documents, and the way that provision you know, get tangled and intertwined and work in between themselves. I mean, you definitely sometimes it's only a lawyer that would understand and would be able to explain to you. Trust your lawyer, and you know, ask him for advice every time you think you need clarifications, and ask as many questions as possible. I mean, no one expects you to be you know, an experienced M&A professional here.
Yeah, and this list only contemplates the ancillary documents for a stock purchase agreement. For example, if it's an asset purchase, a lot of these are not going to be as relevant. Certainly the employment or the management agreement still will, you know, but you're going to have different issues, right? You're going to have, you know, employment offer letters for every employee that's coming over as part of an asset purchase in most cases. You're not going to have stock certificates in that case, but you're going to have bill of sale and assignments of assets and you know, copyrights and trademark assignments and things like that may not, you know, exist in a normal in a different kind of financing. So this list contemplates a stock agreement and not an asset agreement. So, but there's a similar and comparable list of ancillary documents depending on what the structure is. And again, I think you've hit it right on the head. That interconnection between them all is complicated. I've seen the employment agreements have one level of non-compete in it, and the purchase agreement has a whole different one that you know, that aren't necessarily consistent, and there's some gaps in between them, and you know, and so we have to iron those out and make sure that they stay the same, or either reflected the same way in all documents, or only reflected once in the most pertinent document. After all this process is done, we have a set of closing conditions. So now we're getting near the finish line, hopefully. And then how do we get across it and get the client paid? So you have to get everything completed as far as that came up in the due diligence. So if your landlord on your office space has to consent to the lease going to somebody else, right? If all the employees have to you know, come over or agree to stay on with the new company, all of that has to be taken care of. All of the little things that have been flagged at some point in the process, all of those ancillary documents need to be in final form and ready to sign. In the United States, almost every deal you have to get a certificate of good standing right before closing, you know, within days before closing, from the local authority that says their taxes have been paid. They are currently a good qualified company with no issues, at least on the local government side. And then when you line all of those up, you know, so again, sometimes it's also an operational condition as far as you have to release this game or sell this asset or whatever it may be. Now you're almost there. You've got everything all set and ready to go. You know, and that's pretty common. again, time consuming because of all the things that we've covered in this panel, need to get addressed and in final form, 15, 17 documents, all these various employees need to sign on to things and everything. So getting ready for closing, the last phase of this deal tends to be pretty complicated, I think, on our side. I'm assuming there's a local equivalent to a certificate of good standing, Silviu. How does that work?
Yeah, I mean, we have it's less sophisticated here, I would say, from that perspective. I think it's more straightforward. We do not have certificate of good standing, actually. I mean, we do, but it's not. There's no requirement to present such on closing and completion, as you might want to refer to it. What we do is we do an all, lawyers acting for both sides would get together and try to do a very brief run through all the areas of scrutiny, all of the issues which might have been relevant. And it depends on very important, and I wouldn't want to go into this right now, but it depends a lot on basically if you have price adjustment mechanisms and the way that those price adjustment mechanisms would really be regulated in those agreements. So if you have a pre-closing statement of accounts, for instance, or a declaration on, for instance, a net debt, if that would be an element, you can say, or working capital, then that would occur prior to completion, and that would be circulated prior to completion as well. And on employment as well, absolutely. As I was mentioning in relation to the previous slide, you would negotiate a lot on the employment matters. There would be, there could be even, a mirroring or a doubling of non-compete obligations in both the employment agreement, management agreement, employment agreement, and the transaction documents. I mean, this is not uncommon, and it would protect the company and both the investors and the company from, future possible scenarios where you compete against them. I mean, it's once you've gotten to that stage, I think things are more relaxed, even though there will be a lot more work and might be a lot of work around just administrative secretarial work, just getting the documents ready, putting in the signature lines, understanding who what will sign and how many copies and so on and so forth. But I think things tend to get a bit more relaxed at a point in time, even though from a negotiation point of view, at least here at least this is how things go and happen in Romania.
Yeah, there's always, in my experience, with the closing conditions, getting all of those sort of lined up and ready for finalization, there's always something that goes wrong at the end. In my experience, usually it's one of the operational conditions. I think one of my last deals, you had to sell off an asset or come to some resolution with an old partner or an old business partner, and get that resolved before they would close. And that always, somebody gets greedy, and then things take a little bit more time than you thought. So there's always a last minute wrinkle, I think, in my experience, in this stage. And it gets a little bit stressful because it's also a few months into most of these deals. So I think everybody's a little tired of working on it and wants it to be done, and you're so almost there. But I've never seen a deal break down at this stage. Luckily, if it gets to this stage, everything seems to be solvable. And if not, sometimes they push it out to post-closing. If it's something that maybe they'll tie some money to it later. But luckily, if you get to this point, I think the deal will happen. In my experience, there's always exceptions, I'm sure. Post-closing. So again, congratulations, the deal is done. The money has hit your bank account. And then there's a whole bunch of items that have to follow. If there anything that was pushed out, any items that you need to clean up, that's got to happen. And
you're missing, Patrick. I think we both missed the buy the Ferrari from that list. It's not there. I think it should be, really. It's a must. So post closing, the first thing you do is not follow on a due diligence or announce deal or anything like that. Just buy the Ferrari.
Is that for the lawyers or for the clients?
Yeah, unfortunately, not for the lawyers here in Romania.
No, unfortunately not. I was going to put on the post-closing list, pay your legal bill. but actually a lot of that comes out directly of the financing in some cases. But
yeah, absolutely.
But yeah, so really this is, like I said at the bottom, this is the end of the beginning. It's not the end. You know, the deal is closed. Everybody should congratulate themselves. Maybe not quite buy a Ferrari. A nice dinner probably is in order, or some sort of celebration because you got to this point. But really, the very next day, it's time to keep moving on in your new world. But there are still a lot of due diligence items, a lot of financial reconciliations that have to happen in the coming months. Collections and working capital adjustments and things like that will happen. It's not all celebration as much as we wish it were to be so. But again, I think you're there for the most part at this stage. Everything else is logistics, and it is time to celebrate a little. I think you know, this process, like I said, the last big one I worked on took 8 months, which, you know, is on the long side. So eight months of hard work, and you know, all hands on deck for the client studio. You know, everybody was excited. There were raises and bonuses that were coming to people's way at the general employment level. Certainly, the founders, you know, would take a lot of money off the table in this. So I think there is cause for celebration here, but there is still a lot of work to be done post closing. Anything to add on that point, Silviu?
Yeah, it's fairly common for once closing has occurred, for instance, here in Romania, there would be another stage which would entail registration of the transaction with a trade register, with a register of companies here in Romania, and I would like to say that it's a very straightforward process and it goes smoothly, but it sometimes it doesn't. And it doesn't because basically the trade register here is a very peculiar and odd sometimes authority, which requires a lot of documents from the investor or the buyer, as the case may be. And then basically the buyer and the investor might provide all those documents, but just the trade register might consider that the buyer has not, and it might get delayed. So, you know, this seems to be very straightforward, and sometimes people just assume it will go very smoothly. And I would like to, you know, just say that you should pay a bit of attention around that as well, even though you've signed everything was closed. Pay a bit of attention because, you know, it might stir up things and it might get the investor a bit annoyed and stressed over the fact that it you know, maybe the transfer didn't get registered, or maybe have a postponement of the registration by the trade register. Try to help out. Actually, you're a local, right? You should know. You should basically your council should know. Their council, their local council should know as well. But everyone should work together to try to get this as smoothly as possible. And you know, integration is something that takes place in one at a time. So, you know, as Patrick was mentioning, maybe a closing dinner would be the best initial or one of the first steps to take to integrate the teams and bring everyone on board and try to, you know, get everyone to understand the role of the others and things like that, if that didn't happen until that point in time. That's it.
One more question about the trade register. Is that primarily to flag it for tax purposes with the local government, or is that purpose, and what's the threshold for registering? Does every deal have to get registered?
Well, Patrick, I think it's first of all, it's important to determine what type of transaction are we talking about. If we are referring to a financing round, then an investment, then that would entail an issuance of new shares. The issuance of new shares would be subject to registration with a trade register for enforceability against third parties. It all depends then on also the type of company. If we're talking about a limited liability company or a joint stock company, then the laws are different. 2 years ago, the Romanian company law has been amended and does not require the registration of a transfer in order to give full force and effect to a specific transfer, but it still obliges and compels the company to register the transfer in a limited liability company for enforceability against third parties. That is absolutely not necessarily joint stock companies where you have the shareholders register, and then basically if you have a transfer of shares in a joint stock company, then you would just write in the shareholders register, and the transaction document, the sale purchase agreement, together with the reference in the shareholders register, would be sufficient in order to confer the transfer enforceability, general enforceability, and enforceability against third parties. In any case, the involvement of the trade register is something that is required because it's a formality that is, of course, sometimes regarded by foreigners as obsolete. We agree, but nevertheless, it is, again, required in relation to, for instance, issuance of shares and transfer of shares in limited liability company. Of course, this is also relevant whenever we have amendments to the material provisions of the bylaws of a limited liability company, and certain other changes, like, for instance, the change in directorship in companies that has to be registered as well with a register of companies. And all of this is secured by one or the other counsel in a transaction. So either the company or the sellers or the buyer's counsel, who is and should be accustomed to performing this registration.
Great. Now, again, that's you've just illustrated why the importance of having local counsel in a deal like that, because that's not something I think certainly my team would ever be able to navigate in Romania or comparable obligation anywhere else. So that's exactly why I always work with local counsel on every deal. So I think that is the end of the panel. I believe the plan is to have follow-up sessions and breakout sessions to answer any questions that you might have in the audience that we've brought up today in this overview. But we look forward to talking to you all and addressing some of those questions and going into more detail about some of this stuff. And Silviu, thank you for joining me. And this has been a great panel, and I appreciate it. And I hope we get to work on a deal together soon.
Thank you very much, Patrick. The pleasure was all mine. And for everyone else, see you at the conference. I will be there on Monday, the 24th, and partially on Tuesday, the 25th. If you have any other questions, you can find myself and my colleague, Elena Stan, in our RP department, and our IP and gaming specialists within the firm. You will find us at the legal booth, and we're looking forward to answering any other questions or providing any kind of clarifications, including on matters or items discussed in this session. And that's it. Thanks again, Patrick. It was a pleasure.
Thank you. Thank you, everybody. Bye-bye.